Hi guys, it's Kathy. I hope you're doing well. Just ignore the glasses, okay? Can we just ignore it? And just go on like they're not there. Oh, buckle up. Guys, I got some good stuff for you today. Yes, I do. Alright, so the first clip we have is Judge Brown down in Georgia. Don't worry, not thick accents. Don't worry. But we're not jumping right into we're just not jumping right in. We have two little cases before we get to the good one that are pretty good. Don't worry. Then we hit the one that, oh, you're gonna get angry, and it's bizarre, and you're gonna get angry. No, you'll see here. Here we go. This poor lawyer. That's all I have to say. I mean, I don't know how defense attorneys do it. I just don't get it, because they got it on video. They got them dead center, and these attorneys have to pull something out of their hat.
Is there anybody who is handling the bond hearing for Ronnie Scott? I've been in touch with AJ about the case. I thought it was assigned to her, but is somebody covering for her?
What's the charge?
It's aggravated assault. It's that stomping case in the parking lot from 2.5 years ago.
It'd either be AJ or Whitney.
Okay, I mean, I know that AJ had been involved with it. I just didn't see her on the meeting yet. Whitney, are you covering for AJ on this?
No, this should be Miss Judy's case.
Sounds good. Okay, thank you.
Yes, sir.
Mr. Grasso, good morning.
This is actually going to be AJ, Your Honor.
Pardon me?
I believe this is AJ's case.
AJ? AJ, you like you're sitting in the dark.
You know what? Not even have the light on. Good morning.
You look like an angel. You're just backlit. It's okay.
You need a phone camera. A camera, you need a loopy thing.
I know,
Anyway.
right? I have a new camera.
Wait, will you have a flip phone too, Judge?
No, that's not what I meant. I don't have a flip phone. You're the one with the flip phone. Okay.
That's right.
Proud, loud and proud. So we're moving to Ronnie Scott. Mr. Pine represents Ronnie Scott. It appears that this is yet unindicted.
That is correct, Judge. And before we go too far, I want to make sure that you're aware that
And I want to make sure you're aware, the victim in the Ronnie Scott case is not my cat. Period.
have a crowded room. Family and relatives are all present. And
Good morning,
I just don't
family.
want Bush to not know that they're all here with us, all right?
Very good. Thank you. All right. I'm going to hear from you first, Mr. Pine.
No, Bobby. It's not.
Judge, this is the worst case that I have seen in 30 years. It is an aggravated assault allegation. It all has become a political football, and you know how much I hate politics. It started because somebody put up a reel of some people stomping people in a parking lot, or stomping an individual in a parking lot. The incident is something that happened years ago. The victim never contacted law enforcement. In fact, the officer who has brought this investigation, who is with the sheriff's office, who hasn't been an officer from what I can tell for something like 20 years because he resigned before he was terminated for a domestic violence case involved.
That checks out. Okay. Granny, he can't see your text messages unless he looks at the live stream. Just like you can't see his text messages unless you look at the live stream, because YouTube hates my chat. YouTube is Curb stomping my chat.
His wife, basically manufactured this case based on something on social media without even ever talking to the victim.
Manufactured this case based on a video he saw with his own eyes. Manufactured it.
Now, I spoke to the victim. The victim didn't want to say a word about any of this to anybody. He did let me know he never reported anything to law enforcement. He wasn't hospitalized. And when we handled the preliminary hearing on this, it was a case of let's just make this up as we go along. They changed the date of the incident 3 different times. You know, there were sworn warrants describing when this all happened. They don't know what day this happened. They had the year wrong, then they switched to a different year. The whole case it's just pure politics. I think that somebody put something on social media that the sheriff found offensive and decided that he was going to make a name for himself by doing something about it. And he doesn't even have a willing witness.
The sheriff found aggravated assault offensive? Yeah, that's political.
As far as
what
the
is
so-called
what information do you have on when this occurred? You said it happened years ago.
the information that I have on it is that it occurred over 2.5 years ago.
Okay.
And
what can you tell me? What can you tell me about your client?
he has no felony arrests. He has no felony convictions.
Oh, no felony. See how he qualified that? That means he has misdemeanors.
He has virtually no record to speak of except for maybe some misdemeanors. He actually was part of a program that helped people go straight from Groves High School into work that was going to service the ports. I don't think that he's a member of ILA, but he has been employed through the ports ever since he left Groves High School.
Okay, how old is he?
He was born in 2000, so if my math is sound, he is 26 years old.
Okay. And he's from Savannah, from the area?
He is from Savannah, has been a resident of Savannah. His whole family is in Savannah. His girlfriend is present. His mother is present. There is a lot of family and friend support here. And unfortunately, I just couldn't get him out earlier. He's been in jail since February the 24th of 2026. Judge Middleton has given a bond to a co-defendant, and this case got moved from Judge Middleton to you, which delayed the bond hearing. Judge, I had to double check the law. This is something where we are not allowed to do what used to be called an OR bond, and I forgot the newfangled term for it, unsecured judicial release. But I am...
That's what you're asking for. Okay.
I would ask for unsecured judicial release, but I can't. So, because the ag assault is a part of the statute that says it can't be,
right.
I'm going to ask you to set a bond of $1.
Okay. So let me turn to Ms. Junius. Ms. Junius, what can you tell me about?
Thank you. This case is a co-defendant case, Your Honor. The co-defendants are Motrion Williams. Mr. Pine is correct. He does have a bond. The other co-defendant is Jimmy Alexander, who the court is very familiar with. And then Mr. Scott, he doesn't have any felony history. He is 26 years old, as Mr. Pond stated. He has a possession of marijuana and traffic offenses. The most recent was 2018 until he got discharged. He's charged with a single count of aggravated assault as part of a crime. Essentially what happened, my understanding is that this happened about August of 2024. And there were 3 black males, all the co-defendants that I just stated, were in a parking lot at Walmart in Pooler, and they were stomping on the named victim. His name is, I want to say it wrong.
No, Margaret, I'll fight anybody who says you're wrong.
It's Raekwon Tyreek Williams. We're unable to contact him, Your Honor. I've not been able to make contact with him through VWAP. But essentially, he was getting stomped on because of some testimony that he gave in a trial. here in Chatham County. I've not been able to verify any information if he knew them or not. I really don't know much, but Mr. Pond is correct. This was opened by the sheriff's office and the charges were brought forth by the sheriff's office. Other than that, Your Honor, there's not much to tell the court at this time. So the state would defer to the court as far as bond.
All right. Thank you. Mr. Pine, I don't know if I've ever done a bond of $1. But I understand what you're asking for, and we're going to set it low. It's going to be a $500 bond.
Your Honor, do you want me to prepare that order for you?
I do.
What conditions would you like?
And conditions of bond, no new charges. No possession of firearms, replicas,
Thank you,
ammunition.
Ren. Thank you.
I don't hear necessarily that alcohol is an issue here, so I'm not going to order that he have no alcohol, so that's not an issue. I think that's it.
Your Honor, if I could add, Mr. Williams is not on for bond today. He's already been given a bond by Judge Middleton. However, the state does have some concern about him given his criminal history, and so we would ask that Mr. Scott not have any contact with either Mr. Alexander or Mr. Williams.
I think that's fair. Thank you.
I'll put no contact with co-defendants. There is talk that they're trying to find other people, so they might add, maybe this whole case will get subtracted before it's all over, but I'm just going to put in the order no contact with co-defendants to cover a wider net in case other people get sucked into this thing.
Very good.
Thank you, Judge. I'm going to have that order to you as quick as a shake of a lamb's tail. Thank you so much.
Okay. Thank you. All right, Mr. Grasso, let's move then to Shaquasia Jackson.
Good morning, Your Honor.
I just need more time. I need enough time to re-record everything that I have, which is hours long. And I'll put that Rebel episode on my Patreon. I just need time to get it done.
Good morning. And Mr. McKinnon said that, well, actually, you have the Conlon. Are you going to handle this for Conlon?
You can't. You can't go back and watch it. They took it down. They don't want me to play Rebel here on YouTube. Don't worry, though. I have Patreon. I'm working on it.
I'll cover that for Mr. Conlon, Your Honor.
Okay. Let me get back to this. So
I do have 1,700 some other videos that you can go back and watch, though.
Mr. Grasso, you represent Shaquasia Jackson, and
Yes, Your Honor.
I'm going to hear from you first, and then I'll hear from
It's free.
Ms. Junius.
You don't have to pay for my
Jackson is
Patreon.
charged with the ag assault, 2 counts, obstruction of an officer, 2 count. Well, 1, 2, 3.
I just need health care. Is that too much to ask for? I just have to record it. I have to record it. And it's many hours long. No, it doesn't put her in a favorable light at all. It's pretty bad. I mean, it was pretty bad. But the Rebel thing, even last night, it was not live streaming. So I don't know why they stopped live streaming it. It went so far, and then it's not over. It's definitely not over yet. And they haven't live streamed all this week. Now maybe they're taking a week off. I don't know. I have no idea. If only someone could call Sue for me and find out. But it doesn't matter. I can't get it. I can, if they live stream, I'm still going to try to get it. I'll put it on my Patreon. But so if you go to my Patreon, you can watch the videos that I put there for free. You don't have to pay. Just saying. Think about poor Donald. $30 a month. I don't make that much from Patreon, so don't even at me.
3. 1 is a felony, and reckless driving and influencing a witness. So, Mr. Grasso, tell me what you would like the court to consider.
Thank you, Your Honor. So the incident that led to the charges happened on December 13th, 2025. I understand the state might have a different position on the facts, but from what I've been able to gather so far, this is a car accident case. I think the allegations were that Miss Shaquasia Jackson was driving a vehicle looking for her boyfriend, saw him pull into the parking lot. She was pregnant at the time, trying to get a hold of him. She pulled into the parking lot, and when she pulled into the parking lot, hit him with the vehicle, and there was a passenger there as well, and so I believe that's what led to the 2 assault cases. I mean, we tend to view the car crash part of this as this was just as an accident and unintentional. I understand the state might have a different position, but she's been in custody since the 13th. Since that time, we were requesting an ankle monitor bond. In this matter, she's a lifelong resident of Savannah. If she was going to be released from custody, she would live with her mother. That's at 62 Barron Court, Port Wentworth, Georgia. The intent would be that she would have her 4 children who have been kind of just bouncing around with relatives and move in with her. 2 of her children receive Social Security benefits due to being disabled. That's paid to Miss Jackson directly. So if she were to be released, she would at least have something to fall back on. I know that she would desire to work if she was going to be released. And I think given the record here, we would request a release to an ankle monitor with certain exclusion zones. It could be some sort of house arrest type situation, and we think that the risk of fleeing or the danger to the community would be very diminished given if she was confined to a home with an ankle monitor. And then as for conditions, I think normal conditions: no contact with the witnesses, victims, and that's what.
She crazy. Okay, I'm posting a link to a specific, that's my Patreon, but that is that's Sue Chrysanthu in a different case back in 2024. She was great in. So I have a bunch of videos of her. I don't have the whole trial because the trial I think is still going on. It's been going on for a long time. But I did get, I don't know, like a bunch of parts. But that's the page where I'll be putting the new stuff as soon as I record it. I don't work today, so it's a good, I could get some of it up.
I'll be requesting, Your Honor.
All right, thank you, Mr. Grasso. Ms. Junius? Tell me a little bit about the facts. I'm looking at the field arrest report.
Yes, Ms. Jackson is charged with all of those offenses, aggravated assault. She's got 2 counts of that. Namely because she was arguing with her boyfriend. He's the named victim in this case, as well as another that I'm going to mention. His name is Jerry Hendricks. Another victim is Taylor Saxon. Jerry Hendricks is the boyfriend of Miss Jackson, and Taylor Saxon is a woman who was in Mr. Hendricks' car. It's not confirmed whether or not Mr. Hendricks has some relationship with her, but essentially that's the thought.
Oh, he does.
Miss Saxon and Mr. Hendricks were kind of dating or snooping around, even though Mr. Hendricks was in a relationship with Miss Jackson. Miss Jackson had followed Mr. Hendricks in his car. Miss Saxon was a passenger and had kind of watched him for some time. Eventually, she then ran her car into his, causing his car to flip over. And so Miss Saxon and Mr. Hendricks were both in that car. Could have went all bad. And that she had also stalked them because she had placed an air tag in his vehicle, which is how she knew where he was. she got charged with the reckless driving because of the way that she was driving when she did overturn that car. And so she was arrested for those, but she was later, it was later added as a charge of influencing a witness. Detective Corey Wright with the Savannah Police Department was listening to the jail calls. Miss Jackson had called Mr. Hendricks repeatedly and pretty much told him, don't pursue the charges, don't tell them anything. I will harm you, pretty much. Something will happen to you if something happens to me. And so that's essentially where she gets discharged from, but that just comes on the heels of another case that she had open. This was happening in December of 2025. She has a recorder's court case open from November of 2025, probably about 3 weeks before this one, for criminal trespass against Mr. Hendricks again. In that case, it's similar. She saw Ms. Saxon with Mr. Hendricks. She knocked on Mr. Hendricks' window repeatedly at that time. She ripped off his wiper blades. She spat on Ms. Saxon. She hit Ms. Saxon. And at the time, Mr. Hendricks didn't want to speak to law enforcement. But then 3 weeks later, she gets this other case. So the state would ask that Your Honor deny bond. We do believe that she's a risk to Mr. Hendricks as well as Ms. Saxon, and that she's also a risk to reoffend, given that 3 weeks apart, she's got 2 different cases, all domestic violence.
Okay.
Is there an ability to? No, I'm sorry.
That's okay, Mr. Grasso. Go ahead.
Yeah, I mean, I don't think I represent her in the recorder's court case. That was just charges of criminal trespass. There wasn't any. There weren't any charges that were, levied against her for anything against Miss Saxon. I understood the criminal trespass was that I think she broke one of his windshield wiper blades. That was the allegation there. The influencing a witness, though, I don't think that the testimony in the preliminary hearing was that the influence of the witness was not related to Mr. Hendricks. It was related to her cousin, who was a passenger in her car at the time. They got.
Sir, are you telling the judge that she really did do this crime? They're just saying she did it to the wrong person? Are you just telling the judge that she really did intimidate a witness? But but it's a different witness, judge. So it doesn't count? What an idiot lawyer.
To an art. At least this is what my understanding of the police officer's testimony was that it was an argument against with her cousin, who was a witness to the whole situation. So I don't think it was related to Mr. Hendricks. I don't think they've been speaking. But anyways, I just wanted to point that out.
I think the concerning thing here is that she had that encounter just 3 weeks before this particular accident, assault.
Thank you.
That occurred in December.
So that's the thing that concerns you, Judge? She rammed his car so hard that she flipped it over. She's air tagging him. She rips off his wiper blade. She intimidates a witness. She actually got 3 charges in 3 weeks, Judge. She didn't just do it again. She did it again and again.
I understand she was pregnant at the time. Has she had the child?
No, there was a miscarriage.
Oh, okay. But she has 4 children?
Yes, ma'am.
Does she work?
She did have she was working, I believe working in retail prior to being arrested. She doesn't have a job right now, so she collects, if she was to be released on some sort of house arrest, if she had the ability to work, that's one of the things that she would do. She gets income from Social Security to take care of 2 of the children, so that is somewhat of a part-time job for her to take care of when she's not in custody.
That's a part-time job. It's a part-time job for her to take care of 2. I think, what did they say? She had 6 kids or 4 kids? But
Okay. And she lives with her mom?
Yeah.
Okay. So, there's a bond. She'll have to pay a $5,000 bond with ankle monitor. Ankle monitor must be installed before she is released. She's in a strict house arrest. She can only leave the home
They were
for
thinking.
court.
That's why there was no sound.
She meet with you, Mr. Grasso, and for medical emergencies. There's no other reason she should leave the house. She's got little kids. She'll need to figure out how she's going to deal with that. No guns, no ammunition, no replicas of guns, no new charges, no contact with the victims in this case, direct or indirect. Anything else, Ms. Junius?
No, Your Honor, I think that covers it.
I believe that covers it as well. Mr. Grasso, do you know if they share children?
No, they don't.
Okay, so that's not an issue. Okay, so that will be that. And if you'll provide the court with a proposed order, that would be excellent.
Yes, ma'am. Thank you very much for hearing so.
Okay, have a good day.
Speaking of
I hope you did the same.
excellent,
Thank you.
it's time,
Okay.
I believe.
Corey Jackson Davis.
So, okay, now we get to the case. Oh man, it's gonna make you so mad. All these people's lives are ruined. I mean, they can bounce back, but holy cow, this one guy. Oh,
Let's move then to Jonathan Davis. Hello,
morning,
Ms.
Judge.
Watson. Are you the attorney for Jonathan Davis?
Yes, ma'am. Someone else's name may appear on the court's calendar, but I have since filed an entry of appearance, Judge.
Very good. It was Tigner,
Okay.
which makes sense. Yeah. All right. And who's the prosecutor, Ms. Junius? You're the prosecutor on Davis's case.
Yes, Your Honor.
Okay, Ms. Watson, you go.
Judge, this is a motion for probation bond. Mr. Davis has been in custody now since February 25th, I believe, on this arrest, so just over 6 weeks. The allegation in the petition is that he changed his address without the knowledge of probation. I will let the court
It's
know
not
that
him.
Mr. Davis is 28
coming
years
up
old, Judge.
next.
He was born and raised in South Carolina. He was living with his grandparents, and he still lives with his grandparents. I spoke to his grandmother yesterday, and she confirmed that he does live at the residence with her and her husband in South Carolina. In fact, she asked me when he was coming home. Judge, I will let the court know that Mr. Davis is on probation in regards to a burglary and theft by taking conviction from 2018. It's my understanding that he owes a pretty good amount of restitution, Judge. He's informed me that he could pay that restitution fairly quickly. I think it's over $2,000, maybe closer to $2,500. He told me, Judge, that he works at a Papa John's and he also does landscaping work. I will let Your Honor know that I had a previous hearing, a probation bond hearing back in August on this matter. You were not sitting at the time. Judge Bass was sitting for the court. At that time, Judge Bass gave my client an unsecured judicial release. He was released and sent to Effingham because he did have an Effingham hold. It's my understanding that he was released on time served on his probation matter in Effingham, at which time he came back to Savannah. He met with his probation officer here in Savannah and was given permission to go back to South Carolina, which is where my understanding is he's been continuously until he was arrested on his probation warrant. I will let the court know, it's my understanding from speaking to his grandmother that when the probation officer came to the home, he wasn't there at the time, but she tells me that he does live there. So I'm respectfully requesting that Your Honor grant an unsecured judicial release on this matter, but in any event, any kind of bond, Judge, so he can be released on this matter.
Okay, thank you. Oh, Ms. Junius.
Thank you, Your Honor. Based on the information that the state has, the state does believe that Mr. Davis could be a flight risk. He's been on probation since 2019 for the burglary charges that Ms. Watson stated. He does owe restitution. It's $3,000 that to date has not been paid. The original petition was filed in July of last year. And it's because probation didn't know where he was from June of 2023 until July of 2025 and didn't know where he was until he was arrested. He was given a bond and returned to probation. Then he got another addendum to that petition filed on December of 2025 where his whereabouts were unknown again. 5 months after the first incident, probation was unable to contact him again. And so given that, the state does believe that he is a flight risk, wouldn't be able to consent to a bond. He does have a probation calendar call on May the 6th coming up, but that's the only other court date that he has scheduled.
Okay. Ms. Watson, I see the bond order that that Judge Bass did, and he said that he could be released on paying $1,000 towards the restitution owed in the case within 12 months. So he had a period of time to pay it. Has he paid any of that yet?
I don't know if he's paid any amount towards that, Your Honor, but you are correct. He was to pay $1,000 within 12 months of his release, which actually is up until August that he has time to do that. But he's informed me that upon release, he plans on paying the full amount of restitution as soon as he can. And I will let Your Honor know, I disagree with Ms. Junior's statement that my client is a flight risk. He is not a flight risk, Judge. He lives in South Carolina with his grandparents.
Okay. I'm going to release Mr. Davis on unsecured judicial release with all of the usual conditions. No firearms or dangerous weapons, replicas, no new charges, no drugs unless lawfully prescribed, and obey all conditions of his probation. And,
thank you, Judge.
And if you could include the probation calendar call date on that bond order as well, so maybe we can get this resolved.
Yes, ma'am. And I will let the court and Ms. Junius know. I spoke to Mr. Davis's probation officer yesterday, late yesterday, and I asked him what probation was attempting to do with this matter. And just what I said, as I said to the court and to Ms. Junius, I talked about how he plans on trying to pay off the restitution as soon as possible. His probation officer, who's fairly new to the case, apparently he just got on the case, said that he would look into it and call me back. So I'm hoping that this is something that we will be able to resolve relatively quickly.
Okay, very well. And Ms. Watson, we're going to move now to Odashina
Jagede, Judge.
How do you say the last name?
Jagede.
Jagede. Hello, Ms. Y again.
Good morning, Your
How
Honor.
are you?
I'm well. How are you?
Good. Okay, let me take a look. Okay, Ms. Watson. And I'm going to ask you to tell us what you can about this case. And your
Sure.
client.
It is bizarre, so I'll just take a minute. It doesn't appear that Mr. Jagede.
Ms. Wyan, I'm going to let Ms. Watson go first, and then I'm going to bounce back over to you. Okay?
Yes, Judge. This is a 7-count indictment. It all revolves around 3 different incidents because there are 3 different incident dates in the indictment. He's charged with aggravated identity fraud, 3 counts of forgery in the first degree, and 3 counts of perjury. All of it, again, is related to incidents in June of 2025, August of 2025, and September of 2025. Essentially, Judge, all of this, this entire indictment stems from the allegation that my client misrepresented that he had been appointed as a permanent process server in Chatham County. That's where all of this stems from, Judge. I will let the court know, as far as my client is concerned, he's 31 years old. He has, to my knowledge, absolutely no prior arrests for misdemeanors or felonies. I'm only aware of traffic offenses, Judge. He is been in the United States, Judge, since 2019. He is a permanent resident alien at this time. It's my understanding that he is married. He and his wife are separated at this time, but he is married and he has a 17-year-old stepson. He has a degree in biotechnology. Please don't ask me about that because I don't know. But he does have a degree in biotechnology, Judge. If released on bond, my client intends to move to live with friends and going back to Liberty County. That's where he was living at the time of his arrest, Judge. But he intends on living with friends in Liberty County, specifically in Allenhurst. I don't remember if I mentioned this to the court, but after he got married, his wife was in the Army at the time. And that's why he was living in Hinesville, because he had been living on base with his wife until they were separated. And now he's living with friends. Again, I respectfully requesting that Your Honor grant a reasonable bond to my client in this matter. He's been in custody continuously since the date of his arrest on January 9th, 2026.
Okay. Ms. Wygan, what can you tell me?
I do not have a traffic offense. I do not have a traffic offense, just so you know. All right, here we go, guys. Get ready. Are you paying attention?
About this case.
Thank you, Your Honor. Yes, we also have no information of criminal convictions. I believe he became a United States citizen in July of 2024, so that information is a little different, maybe from Ms. Andretz. It is a bizarre situation. Judge Sapp called the sheriff's office and alerted them that he had come across an order with Judge Sapp's own signature, which didn't look authentic. And sure enough, as the investigation wound up, they've discovered 177 filings in which Judge Sapp's signature was forged. It was forged from another order designating a process server. Mr. Jadege fraudulently created an order using Judge Sapp's signature and filed that as long as perjurious affidavits in about 177 cases, which Judge Sapp's office is now having to unwind. Originally, we thought, well, what's the motivation behind this? Well, Mr. Jagede was employed by ABC process servers and was submitting for payment for these fraudulent services upon several victims. And come to find out during the service of the search warrant that this was going on in Bryan County, Liberty County, Effingham County, South Carolina, and Florida. So on scale, the money made more sense. While he earned approximately a little over $11,000 from this fraud in Chatham County, when you consider the additional states and counties, it is much larger. And not all of those counties and states have initiated investigations. But we went ahead within the 90 days with the charges that were easiest, and we have all the documents for. I got an additional set of documents from the investigator yesterday when he came to my office for a meeting. I will note that during the service of the search warrant, they found a Nigerian passport, which does suggest, and they left it obviously outside of the scope of the search warrant, and they left it. So it does suggest that there is a risk of flight in this case, Your Honor. He is originally from Nigeria. Let's see, we have the fraud seemed to have gone on from October 8th of 2024 through September the 10th of 2025. Having submitted for payment through ABC work that he did in performance of these fraudulent services with the forged order does raise it to aggravated identity theft, given that he gained employment based on that fraud. And there's a concern that this, given the scope of this, while only 7 counts have been indicted thus far, that there may be an additional indictment coming and then a subsequent motion to join the cases together to deal with all of them at once. It is not just Judge Sapp's and the administrative burden of having to go back and unwind and vacate orders of default entered upon the reliance that the defendants had been served in these cases, but the individuals themselves overall seem to have been a group who unfortunately were suffering financial straits and had in the past been the defendants in cases mainly in credit card reclamation cases. So it seems that unfortunately this group that was already financially disadvantaged now has the additional headache and a half of trying to unwind either a lien or default judgment that was entered against them in reliance that they had been served when in fact they had not been served. The state opposes bond at this point, given those reasons, Your Honor.
Okay, thank you.
So he forged judges' signatures on hundreds of orders and then told the courts, yeah, I served, the people were served. I served them. And he didn't. And then the court case came and the people say that they were served, they never showed up. Default judgment against them right away. Now the court has to go back and find all these cases where there was a default judgment put against these people who are already freaking broke and try to fix it so that they can get a real day in court. And North Carolina, Florida, all of these counties in Georgia, they said, I think in Chatham County it was 177 people. Who knows how many it is across all of the counties and states that he did this to. All of those people got lost in court without even knowing they had a court date because they were never served. Oh.
Ms. Watson, you get the last word.
Yes, Judge. All I can say in response to that is, again, what I'm looking at right now is a 7-count indictment. If additional charges are going to be filed at some point, that's at some point down the line. I can only deal with what I have right now. I'll also state to the court that I have seen the search warrant, which was executed in this case. Of course, the state has more access to what I have, but the return of service that I have, which is undated, unsigned, and handwritten, merely states that they discovered, in addition to some computers, that they recovered a, quote, stack of documents, and then later on in the return it says another stack of documents. So I don't know what they have. But again, I'm asking for a reasonable bond on for my client at this point in time. He has no prior felonies or misdemeanors, and he will abide by any conditions that the court wants to place on bond. And I also just want to state, you could be correct as far as he's been a citizen since 2024. I said that he's a permanent resident. I didn't say when he became permanent resident, just that he moved here with his wife in 2019.
I'm going to set a bond, given that it is not a violent matter, it's certainly a concerning matter. The bond is $6,500.
Add a zero to the end of that, Judge.
He has a passport. I am going to ask that. I wonder who could keep this.
You're talking about surrendering his passport? I don't know, Judge, but I will let the court know that I believe that would be something that you would say, and I mentioned that to my client. As far as the mechanics of it, I don't know, Judge.
Because nobody likes to keep anything.
Right.
Okay, surrender his passport. I guess he could give it to you, and then I'll figure it out.
Well, see, I don't want to keep it either. But anyway.
I know. And I don't want him to have to give the passport back to the passport.
I know what you mean.
Yeah.
Anyway, put that in there. If I don't figure it out, I'll cross it out.
Yep. We'll figure out later. Yeah. Okay.
Yeah. Okay. There are no co-defendants known in this case, correct?
Not to
That's
my
correct, Your
knowledge.
Honor.
Okay. Not violate any laws. We'll say no guns. Although I don't think that's an issue here. And surrenders passport, and I'll figure that out.
Yes, ma'am.
Okay.
Is it the habit to have it surrendered to defense counsel? A sort of like it's property for safekeeping?
I have never recovered someone's passport.
Yes. Nobody wants to keep anybody's passport, but I'm sure it's happened around here. I'm going to figure out and inquire. So we'll sort that out. Just put it in the order, though.
Thank you.
Okay. All right. And does Mr. Jagede, does he have a court date coming up? Ms. Davis?
I think he has an arraignment coming up in next month, Judge.
I did see that.
I'm sorry. Yes, Judge. He has a court date on this month, May the 4th at 11 a.m.
Okay, let's do
I didn't look to see. I have May the 4th. I didn't look to see if I got it yet. We'll keep an eye on him.
this. Let's tell him to bring his passport to the arraignment.
Yes, ma'am.
I'll figure it out by then.
Okay. Yeah, because of my research, I'm looking on trying to research it while we were on the hearing. It says possibly the clerk's office. I don't want to say that they can.
That's what I was thinking, but I'd want to check with them first before I.
Yeah, I know prior settings, private counsel has been able to keep the passports. Not Miss Watson, not the public defender's office, but like private retained counsel have kept passports in the past.
I didn't say nobody wants to keep anything for safekeeping because anything can happen, but my thought is the clerk's office. So
Yes, ma'am.
go from there. Ms. Davis, thank you for checking.
No problem.
Okay. And is there anything else on today's docket that has not been addressed?
Not with me, Your Honor.
All right. Ms. Wigan, Ms. Wigan. I'm going to get it right one of these days. Ms. Watson and everybody else on, have a good weekend. This completes this docket.
Thank you, Your Honor. Have a good weekend.
Thank you.
See you later.
Okay. Sorry for the delay. Good afternoon. This is the 27th of April, 2026. We're here for.
You heard that right, Jude. I told you were going to be mad. I told you it was going to make you mad. And the more you think about it, the angrier you get.
The afternoon criminal trials period series. President of the courtroom today is the state of Indiana by its separate prosecutor. Sir, if we've met and I have forgotten that we've met, I apologize. I'm Senior Judge Nancy Gettinger. Sometimes very senior judge and I forget things. If we have met and I have forgotten, I apologize. You are?
DPA Danielson.
Very good, thank you. Probation Department is here by its officer. And I think we are ready to proceed. You may call your first case, sir.
Thank you, Your Honor. They would like to call State v. Paul Theodoros, 2604 CM 968, set for initial hearing.
Thank you very much.
Hello, how are you?
I'm good. You are, in fact, and I don't want to mispronounce your name, is it Theodoros?
Yeah, Paul Theodoros. Yes.
Sir, did you have an opportunity to review your rights today?
Yes, I understand. Yeah, review them. Sure.
Your rights?
Yeah.
I played the rights.
I all the way up to the point of my release till today.
I'm asking you if you've understood your rights.
Yeah, but everything I heard up into that memoir or that thing that was spoken to me.
Your date of birth, please.
10/1986. It spoke about
Your current address, please.
my current address is I live in 287, or I have an apartment that my Illinois ID goes to, but I no longer live there. 21310.
So where do you live?
Where do I live?
What is your
I'm making my way to where my federal compensation, the VA compensation check for my VA for healthcare, for my deployments in my past for
welcome
Army.
back, Billy. It's good to see you.
That's where I was heading to. But I was going to my friend's house in Lafayette first.
Sir, please, I need an address.
287, but I don't, yeah.
Slow down a little bit and speak up. 207.
South Carolina.
Is there a city?
Hardyville, South Carolina.
Hardy. Thank you. And your date of birth again, please?
My date of birth is 10/1986.
How old are you today?
What's that?
How old are you as we sit here today?
I'm 39 years old.
Good. We're here today for an initial hearing. Could you please advise the defendant of the charge as well as the potential penalties?
Thank you, Your Honor. On or about the 23rd day of April, 2026, in the County of LaPorte, State of Indiana, Paul Theodoros did unlawfully, knowingly, or intentionally exert unauthorized control over property of another person with the intent to deprive the person of any part of its value or use. This is a Class A misdemeanor punishable by up to 1 year in LaPorte County Jail and a fine of up to $5,000.
Thank you. Do you understand what you've been charged with?
Oh, yeah, on my walk to receive my federal compensation, which I've yet
Do you
to
understand what
correctly.
you've been charged with?
Yeah, on my 90% tax-free compensation check, I've yet to use correctly. I'm on the way to that. I understood the charge that you spoke of, on the way to getting that, receiving that.
Do you understand the
I mean,
potential?
I can bond out right now if I had the right people around me.
Do you understand the potential penalties for that charge?
What was that again?
Do you understand the potential penalties for that charge?
What was the penalties?
Could you please give him the penalty again? I'm sorry.
Punishable by up to 1 year in LaPorte County Jail and a fine of up to $5,000.
Do you understand?
I understood what they said. Understand, I'm not sure, but understood the words, yes, understood. On my way to receive my 100%. On my way to receive my 100%, which was already given.
I'm going to set it at standard bond for a misdemeanor in LaPorte County at $600 cash only. Are you going to be hiring an attorney to represent you?
To do what?
Are you going to be hiring a lawyer to represent you?
To do what?
Are you going to be hiring an attorney to represent you in this matter?
To do what?
Do you want a lawyer?
To do what?
To represent you. You've been charged with a crime.
Is there 50% or is it full 1 year's term?
Appoint a public defender to represent him at this time. It may involve a competency evaluation as well.
May 26th at 8:30.
May 26th at 8:30.
Hey, remember, are you Irish, Jeffrey L. Thorne?
I am not Irish, but we're going to.
Hey, well, make sure the water's nice and green in fucking South Carolina on my way to it. Make sure it's nice and tax-free once I fucking get there. Disrespectful fucks.
We'll call the next case.
I wish I had the power of contempt. I wish more judges used their power of contempt. I just do. This guy's funny. We're going to go to another guy.
All right, we are on record 2502 CM389, State v. Miramaj Mason. Parties are, the defendant is present here, staying in person. State's present by Deputy Prosecutor Jacob Moore. We were set today for a bench trial. Are the parties ready to proceed?
Yes, Your Honor.
Yes. Okay. Go ahead, State.
Thank you, Your Honor. The state calls Trooper Elena Thoman.
So you guys are going to ask, is this a SOV set? And I'm not going to say no, it's not a SOV set. But I'm not going to say yes, this is a SOV set. It's adjacent. Let's just say SOV set adjacent.
Okay. Do you swear or affirm the testimony you give today is the truth, the whole truth, and nothing but the truth?
Yes, I do.
You have a seat. Go ahead, State.
Thank you, Your Honor. Good morning, Trooper Thoman. Could you please state your name and occupation?
My name is Elena Thoman. I work for the Indiana State Police as a senior trooper.
And how long have you been employed as a trooper with the Indiana State Police?
A little over 11 years.
Okay. What are your duties as a trooper with the Indiana State Police?
I patrol county, state, federal roadways. I work crashes. I do criminal investigations as well.
As part of your duties, do you also enforce Indiana traffic code?
Yes, I do.
Okay. Were you on duty in your capacity as a trooper with the state police in Montgomery County, which is in the state of Indiana, on February 4th of 2025?
I was.
And did you come into contact with an Miramaj Mason?
I did.
Is Mr. Mason here in the courtroom today?
Yes, he is. He's wearing a black sweatshirt and black pants with black shoes.
Your Honor, Trooper Thoman has identified
Excuse me, ma'am, that's his best black sweatshirt. He's in court.
the gentleman sitting to my right at defense counsel table.
Record will reflect that.
Can you please explain to the court how you came into contact with Mr. Mason?
Yes, I was patrolling in the area. I was eastbound on I-74 near the 44-mile marker. I was traveling in the left lane when I noticed a vehicle coming up from behind me at a high rate of speed. I moved to the right lane. That vehicle then passed me. As it was passing me, I could not read its license plate until my headlights could illuminate it. And I ran the plate. And due to the speeding violation and the license plate light violation, I initiated a traffic stop on them.
Trooper Thoman, first off, is the 44-mile marker in Montgomery County?
Yes.
Okay. And then you said that you observed the Chevy Impala speeding. How did you determine that that vehicle was speeding, exceeding the posted speed limit?
I was traveling 73 miles per hour, and again, it came up from behind me at a high rate of speed. I did not have my radar locked in at the back, but with it gaining on me and then passing me, it was going over the posted speed limit of 70.
Now, as it passed you, was that vehicle within?
Look, if you're gonna get a speeding ticket, do it while you're passing a cop. That's a great.
50 feet of you?
It's under 50 feet. Each traveling lane is about 12 feet. And from where I was sitting to where the license plate is, it was about 12 feet.
Okay. And were you able to observe clearly what that license plate would read?
Not when it was directly next to me.
Okay. Did you effectuate a traffic stop on that vehicle?
Yes, I did.
Okay. What happened after you got that vehicle stopped?
I approached the vehicle. I spoke with the driver. I asked for his driver's license. He could not provide one. And then I had him step back to my vehicle so we could figure out the rest of the situation.
Now, the driver, I'm assuming Mr. Mason?
Yes.
Was there anybody else in the vehicle with Mr. Mason?
No.
Okay. Now, were you able to determine if Mr. Mason was a valid driver since he didn't have his license on him?
Yes, I ran him by name and date of birth. He was also the registered owner of the vehicle. And the driving status showed suspended prior.
Okay. Were you wearing body camera that captured your interaction with Mr. Mason?
Yes, I had body camera on and in-car camera.
Were you able to review your body camera prior to today's hearing?
Yes.
Is it a true and accurate representation of your interaction with Mr. Mason that day?
Yes.
Your Honor, at this point, the state would move to admit State's Exhibit 1, which would be the body camera of Trooper Thoman, and publish that to the court.
Any legal objection? Okay, we'll show one admitted.
Your Honor, if you could. Yep. And I believe I figured out the sound you were having the last
There's no tasers or meltdowns in this body cam. Unfortunately. Is that too much to ask? Couldn't you pull out a taser? Whatever. So, body cam footage always has no sound for the first 30 seconds. But it'll come on.
You don't have a license plate light? Or it's very dim and dirty? Very well, and I'm directly behind you. Wait, your license and registration? You don't have one on you, or you don't have one period? You give the registration of the vehicle. Okay, where is that gun located? Okay, don't reach for it. Do you have is the registration in the gun on you? Your car? You push your car? Okay. If you don't have a driver's license today, or you just never had one, or what happened with it? Okay. So you think it may still be suspended? You just don't have one valid. Okay. And then the gun is it under the seat? Or is it under your leg? Is there a holster? Did you just get off work right now? Okay, where do you work? Oh, okay. Okay, then I'm sure you step out of the car if you don't mind. Just so we can work all this out. And I'll have you step back to my vehicle. You're fine. I'll have you step back to my vehicle and we'll talk about it. Do you have anything on you? No? Okay. Well, that's fine. Close the door. Nothing in your waistband, no? You turn there. You just have me come back to my car and then I'll get your name and date of birth and everything like that, okay? Let me move a box real quick. very dim if it is there. But the license plate light we should be able to see it at least 50 feet. And I had to get like right up on you to see your license plate. So you just have to see in there. Were you Mason last time? You see that you are strong. Your address is at the
We don't need registration. We don't need to carry registration around here anymore because it's all electronic. And my insurance, I haven't had a paper copy of insurance in a while. It's on my phone. I just show them my phone. But I do carry my license with me. I use my... Never mind. I like where his defense is going here in a minute, once the body cam is over.
I'm going to stop the video now. Trooper Thoman, did you remain on scene, it appears, for about another hour, waiting on Mr. Mason to have a ride to come and get him?
Yeah.
Okay. Your Honor, at this time, the state would move to admit State's Exhibit 2, which was the certified DMV record of Mr. Mason's driving record.
Any objection to that, Mr. Mason?
Nope.
Show 2 admitted.
Right here, State's Exhibit 1. Thank you.
Go ahead, State.
Thank you, Your Honor, and thank you, Trooper Thoman. I don't have any further questions.
Mr. Mason, do you have any questions for this witness?
Yes, I do.
Here we go.
Trooper, how often are you in violation of Indiana basic speeding laws?
Your Honor, objection. That's outside of the scope of direct examination.
Sustained.
Trooper Thoman, you testified that you were doing 73. What was the posted speed limit on I-74 East?
70 miles per hour.
So you are aware that you were over the speed limit at the time that you came into contact with the defendant, right?
Yeah.
So does that mean that you were in violation of Indiana basic speeding law?
I was traveling 73 miles per hour in 70 zone.
So you were in violation of Indiana basic speeding law?
Yes.
And at the time that you were in violation of Indiana speeding law, you were under suspicion that the defendant was in violation of Indiana basic speeding law?
Yes, you were traveling at a higher rate.
Trooper, can unlawful conduct be, I'm sorry, 1 second.
Trooper, we were both speeding, so how dare you pull me over?
Knowing that you were in violation of basic speeding law, why did you pull over the defendant?
You were traveling at a higher rate of speed. You had a license plate light out as well.
Reasonable suspicion must come from a lawful, come from lawful conduct and lawful authority. Do you think, in your opinion, that your conduct violating Indiana basic speeding law was lawful?
Your Honor, I'm going to object. This line of questioning seems to stem exactly from the motion to suppress hearing that was previously held in this matter, in which the defendant had an opportunity to raise these issues, did raise these issues. The court ultimately denied that motion to suppress.
I'm sustaining the objection. The issue of the constitutionality of the stop has already been decided by the court. So we need to move on to a different line of questioning.
But Judge, she was speeding too.
However, it's been misrepresented, though, because in the suppression hearing, it was Trooper Tomlin testified to the same thing, to the same way as to getting the reasonable suspicion. And you have a due process to ensure that you take discretion and ensure that my constitutional rights are not being violated at no point in time throughout this process.
That
And
sounds
I've
legit.
raised immediately after the suppression hearing that this officer testified that she was in violation of basic Indiana speeding law. And I've also tried to get the record to show that she did in fact testify that she was in violation of the speeding law. So
Just let me get this straight, sir. Are you suggesting that being in violation of the speeding laws is a bad thing? Because that's probably not something you want to press right now.
So at this
Unless you're
point,
racing,
it appears
exactly.
that the state is trying to misrepresent the facts and further prosecute an unjust and a prejudicial call. Prejudicial call.
Okay, so what the court heard at that hearing was that due to either a dim or inoperable license plate light and exceeding the posted speed limit, the officer had reasonable suspicion to conduct a traffic stop. At which point the issue is before the court today, whether or not you were operating a vehicle with a suspended license was brought up. And that's what we're here for today, to see if the state can prove beyond a reasonable doubt that you were operating with a suspended license. The issue of the admissibility of the stop, the constitutionality of that stop is
I have no idea what he's saying. He's using a whole bunch of words, though, so I'm sure he's right.
already been determined by the court. Okay, so we can move on to a separate line of questioning.
Well, I have no further questions because at this point, it appears the court is going to overrun and do as it wants.
Of course, it's just going to do whatever it wants to do.
Your Honor, thank you.
You can step down. Any other evidence from the state?
Just argument, Your Honor.
Any evidence, Mr. Mason?
No.
Argument state.
Your Honor, the state believes that it's proven beyond a reasonable doubt that Mr. Mason was operating a motor vehicle in Montgomery County in the state of Indiana on February 4th of 2025, that his driving privilege, license, or permit was suspended or revoked as evidenced specifically on page 5 based on a prior driving while suspended that occurred out of Marion County Superior Court 24 with a date of conviction of 3/22 of 2023. We also believe that Mr. Mason verified his name, his both first and last name, and the address on 26th Street, which is also listed on page 5, and therefore the state believes that it has reached beyond a reasonable doubt its burden of proof, and would respectfully request the court find Mr. Mason guilty of driving while suspended with a prior conviction occurring in the past 10 years.
She's just a bad loser.
Additional argument,
Bobby,
Mr. Mason?
you're right.
No. So the court is going to find Mr. Mason guilty of count 1. The state has clearly proven beyond a reasonable doubt that Mr. Mason was suspended on the date in question in February 2025. Particularly, it's like on this driving record suspension 28 showing that was suspension through March 5th of 25. There's also failure to file insurance that existed without expiration. We can proceed to sentencing. Mr. Mason, is there anything you'd like me to consider on sentencing today?
Father of 4 children. I currently do not work at this point. Had a job out of here, which I was coming from at the time that this happened or whatever. So I'm not currently employed right now. That's it.
Any questions, Dave?
No questions, Your Honor. Thank you.
Mr. Mason, do you have sole custody of those kids, or who has those kids?
Well, the mother, due to Indiana law, the mothers have custody because I was up there when I had my children. But I am active in my children's life.
Okay. Any other evidence?
That
on sentencing?
On sentencing.
Anything state?
Your Honor, the state would just note for the court.
Bren, maybe I will go to Indiana and break the law. And that way you will see such a case.
Evidence or argument, Your Honor. I apologize.
We'll start with evidence.
No further evidence, Your Honor. Thank you.
What's the state's request?
Your Honor, the state would respectfully request a 10-day sentence to Montgomery County Jail with a 90-day license suspension and court costs to be imposed. The state's not requesting a fine. The state's of the opinion that, as evidenced by Mr. Mason's certified driving record, he has, by the state's count, at least five prior driving while suspended convictions, the most recent of which occurred in a level 6 felony cause in which Mr. Mason entered a plea agreement approximately 18 months to 2 years prior to this event occurring. The state believes that Mr. Mason was treated on roadside about as respectfully as possible. Trooper Thoman allowed him to come back to the car, reacted appropriately when she discovered that there was a firearm in the vehicle, and waited approximately an hour to allow Mr. Mason to have someone come and get him so he didn't have to get arrested. The state believes that Mr. Mason doesn't really have any mitigating factors. He doesn't have custody of his children. He's not employed, so there's no concern about him losing his job. And that based on this repeat criminal conduct, that a sentence to the Montgomery County Jail is appropriate. Thank you, Your Honor.
Generally, in considering a sentence, mandatory on felonies, misdemeanors, court has to consider aggravators and mitigators. Generally, in a situation of a driving while suspended charge, the court sees entering into a plea agreement, admitting the wrongfulness of the actions as a significant mitigator, and that is absent here. Mr. Mason's been given ample opportunity to discuss with counsel, was given the opportunity to have a public defender appointed, has continually refused that. So I am going to go with the state's recommendation. Since it's going to be 10 days to the Montgomery County Jail, it's going to be 5 actual. There's no pre-sentence credit. It's court costs of $189.50, and there'll be a 90-day suspension that will go into place tonight at midnight. So sir, you're going to be remanded into the custody of the Montgomery County Sheriff, and in 5 days you'll be released from the Montgomery County Jail. Okay, that's all for today, sir.
5 days in jail.
Your Honor, could the court please advise Mr.
Yes.
Mason?
So Mr. Mason, you do have 30 days to request an appeal of this, and you do have the right to have counsel on that appeal. So you steps to be file a notice of appeal or contact the court.
I will be requesting an appeal.
Okay. Do you want to have counsel appointed?
I want counsel appointed as second chair.
You're going to request an appeal of this. You'll already be out of jail before anything in the appeal happens, though. Maybe, I mean, his license is already suspended. Now he's got 90 more days. Maybe that's what he wants appealed.
Okay, well, there's no second chair. You're going to have an attorney who is advising you on this, or
no, I will
proceed pro se.
Proceed pro se.
Okay.
Sir, you can't use your phone.
Very smart.
All right. You still understand that you'll be considered given the same obligations as an attorney as you go forward with that?
Absolutely.
Okay. So we'll show these waive your right to counsel at this point for the purpose of appeal.
I mean, maybe, but he was clearly driving with a suspended license. Well, at least he's being nice. He's not swearing like the other guy did. 5 days off work. Oh man, if I took 5 days off work, I would be in big trouble. Oof. Oof. Alright. Okay, this one's a little weird. Good
morning.
Good morning, First Judge. Good morning.
Okay.
What about Mr. Garland, Judge, in custody? Yeah, it looks like a new case has popped up here.
Another case?
Injury to elderly, Judge.
Tell me, we were just here about something.
It might have been that case, Judge, because I see a setting from 4-7.
Really? I thought we were talking about the MAJ.
There is the MAJ, and then there's the AFM impeding second, and then there's injury to elderly.
Ms. Regina, we're talking about Garland. Does the injury to elderly predate any of these cases? Or did he make on the MAJ and the new law violation, and then the injury to elderly occurs?
The injury to elderly was actually from, it occurred, so chronologically it occurred after the AFM second, but was not but before the second was filed.
So it could be alleged on the motion.
So the loud talking you hear in the background is the defendant. He's talking.
Was after he was placed on supervision?
Yes, because he was placed on supervision, if I'm not mistaken, in 2025.
Yes, my agreement.
The injury elderly is from.
I'm not sure.
No.
I don't know, V, maybe I'll test that.
I'm not doing that
No,
plea
joking.
either. Sir, Mr. I'm not doing that. I'm not doing the plea. He doesn't know what's going on. I see some medication.
Yeah.
No, he already had an evaluation. He wanted to have questions. I said,
Tell me your client's name.
He was about questions. I asked him.
Yeah, I wanted to see what misdemeanor.
Tell me your client's name.
Eduardo Cardenas.
I got my birth certificate.
No, you're good.
I don't know, breakfast.
I'll do first. My bad.
I see there's.
Yes.
All right, we're about to hear what he did assaulting an elderly person. It's not something we've heard before.
Two MAJs. But the amended MAJ deleted the AFM second allegation, and it's just the injured elderly.
Say that one more time, I'm sorry.
There's initial MAJ filed on the AFM second, when the AFM impeding second letter was filed.
No, it was.
Then when the injured elderly was filed, when the MAJ was amended, but the AFM second language was dropped, and it's only the injured elderly that's alleged.
Okay, the motion I'm seeing, it only has the
That's Michael.
assault family member impeding with the prior.
So just be amended that reflect on that. Yeah.
What's the PC on the injury to elderly?
The complainant, 76 of the time of the offense, he was doing yard work outside his residence, and he with trail riders passed by his house.
Okay, it's really hard to understand, so I'm just going to fill it in for you. 76-year-old man was outside of his house, and in Texas, he was doing yard work, and a bunch of people on horses came up, was riding by, and he didn't want them in their lawn, so he stacked a bunch of wood up so the horses wouldn't get to the lawn, and it scared the horse. Okay? I wish I drank all day and downloaded court videos at night. I would love that.
Not want horses in his yard and attempted to make a fence out of logs, act as a deterrent. One of the horses got startled by the complainant. The defendant was riding the horse and charged at the complainant. He then used a horsewhip to strike the complainant several times, causing pain and injury. The complainant had to get 6 staples in his head and additionally have bruises on his back.
He horsewhipped
And is
him.
a neighbor?
I don't think it's his actual neighbor. I think they were just riding through the neighborhood.
I see. Okay. So was it just being investigated?
They had to do a photo lineup, and so I think they referred for the identification.
Got it. And can you tell me the offense date again?
It's going to be on 2/7/2026.
Okay. Mr. Gardner? Can you tell me about Mr. Gardner?
And I don't have, I was just looking through my, I don't have that information really offhand. I'll defer to the court. I don't think he's going to be
Bond. Okay.
So I'll refer to the court.
The 2 bonds are set at 100,000. Okay, I'll set this one at $300,000.
Yes, ma'am. And then judge just asked for a reset date to get the information.
Because now you got to get the discovery on this new case.
And we're getting medical records, judge, so we're issuing some things for this hopefully.
Okay.
That's it.
All right.
Did you get the bond amount?
We heard the bond amount, $100,000. That other guy should have got $100,000. Seriously. Wait. 3 cases, $300,000 total was his bond. Let's do an Ocean's 11 case real quick.
That's a add-on, so let me put it.
Okay, this one does have a bit of an accent, guys. You'll be fine. Breathe through it.
Didn't have the indictment number.
I do. I got it right here. It is case number 2018 R0040. And Mr. Millick, you're the one that filed a motion to set aside the bench warrant, right?
Correct, Your Honor.
Okay. And Mr. Brooks in the back?
He is.
All right. There he is. Okay. On the way. Okay.
And I put the.
This is, thank you. Let me handwrite this onto my calendar. Give me just a minute. Before we get on the record, this is the one where, I don't know if Mr. Brooks had ever even been arraigned, but there was a bench warrant from years and years and years ago.
Grand jury warrant from 2018, Judge.
And he just got picked up.
Just got picked up, yeah.
All right.
And we've been trying to figure out how that happened because he's been working and all that kind of thing, but.
Who knows? All right, well, the court calls it this time case number 2018 R0040, State versus Marquise O. Brooks. That's you, sir?
Yes, sir.
I'll note for the record that Mr. Brooks is standing at the podium with his attorney, Mr. Jonathan Melnick. I understand you have a negotiated plea, is that correct?
That's correct, Your Honor.
Do you have a plea sheet?
Yes.
Oh, there it is at the bottom. All right, very good. Give me just a second. Let me take a quick look here. Facts of the case, please, sir.
This case has been a long time coming. Accountability filing. This situation goes back to, let's see, September of 2016. A burglary occurred here in Bleckley County at the Crossroads 4 convenience store. Mr. Brooks apparently was part of what I could say is a very sophisticated ring of gang of burglars who were hitting convenience stores throughout the state. And a lengthy multi-jurisdiction investigation led to finally the apprehension of some of the members of this gang. They were using sophisticated means. It's almost like an Ocean's 11 kind of thing. I give it to them. They had people doing lookouts. They had a technique whereby they knew when law enforcement, how long it would take for them to respond. Like I say, very sophisticated, organized. I don't think Mr. Brooks was a ringleader by any means. But what occurred here in Bleckley County was they smashed through the front door of the Crossroads, stole several items of merchandise, and took the safe, which contained somewhere close to $11,000. And again, this took a long time with many agencies to uncover who was behind this organized ring of burglars. So Mr. Brooks was never apprehended in Bleckley County, and it was not until sometime later into 2017 when the whole organization of this was uncovered and the investigation finally was able to identify the members. So good that Mr. Brooks has taken accountability. I've heard from his attorney that he has turned his life around, that he's has a family, he's working hard, and we just ask that you accept this.
Anything from the defense, Mr. Millen?
Just to add on to that a little bit, Your Honor, he's 30 years old now, so this happened, he was in his early 20s when all this happened, and he's been working and doing right. He hasn't had any he's had there are a few cases of a similar nature from the same time frame that are out there, but he hasn't had any subsequent arrests since since 2017 or 2018. So he's been doing good. Hopefully this won't be too much of an impediment against him.
Your Honor, yes, one more thing I'd like to put on the record. There is another pending case in Telfair County that involves Mr. Brooks. similar situation. Again, part of this organized ring of burglaries. And my office has agreed as part of this plea, which I forgot to mention in the beginning, is that we will not pursue the charges against Mr. Brooks in Telfair County.
But it's not indicted? Or is it? Well, if it's indicted, just get me a null process, otherwise
Yes, Your
dismiss the warrant.
Okay.
All right, very well. Mr. Brooks, well, that's all very encouraging. I'm glad to hear that. I don't have any explanation as for why this case has been on the dead docket for 8 years.
Yeah.
That's a long time for a case to still be kicking around, but anyway, it took a while, but very glad to hear that you're doing good. Do you have any questions about anything that has happened up to this point?
No, sir.
Is there anything that you would like to say? You don't have to, but you can if you want to.
No, sir.
Very well. The court finds that the plea has been freely and voluntarily entered, that there is a factual basis for the plea, and the court will accept the guilty plea to both counts and the recommendation. As was stated, count 1, 10 years on probation, $1,500 fine plus the add-ons. Count 2, 5 years probation concurrent to count 1, which means it runs at the same time. The probationary part will be served under drug and alcohol conditions, Fourth Amendment waiver conditions. You'll be banned from the Oconee Judicial Circuit. You have a period of 4 years to file a habeas corpus petition from the date the sentence becomes final, 30 days to file a notice of appeal or a motion for new trial. Do you possess a concealed carry permit for a firearm, Mr. Brooks?
No, sir.
All right, Mr. Brooks, that will conclude your case. You'll need to meet with Officer Long here from probation who'll process you through, but that will close this case. So, Mr. Millick, you have any other business today?
I don't, Your Honor.
Well, you are excused. Nice to meet you both. Thank you, sir.
Ocean's 11 gets 10 years probation. So, did you get good time on probation? Is he going to do 10 years or is he going to do 5 years? All right, last clip. The lawyer goes on a little mini rant here.
Good morning, sir. Good morning.
Good morning, Mr. Kynes. We're here on cause number 2511 F6 1132 for Mr. Kynes. We're set for sentencing today. Mr. Kynes, are we ready for sentencing today, sir?
We are, Your Honor.
Good. Good morning, Mr. Kynes.
Good morning, sir.
So we've got that pre-sentence investigation. Did Mr. Kynes have an opportunity to go over that, sir?
You did, Your Honor.
And did you note any errors or corrections that need to be addressed?
Well, Your Honor, on the credit time issue,
Okay.
probation, I guess, is unilaterally asking that that time go to parole. We're asking for the opposite. He was held on this case legally. He is entitled to it. We would ask that the court take the credit time that it deems appropriate and then let parole sort it out. My client believes his parole will be expired and extinguished here shortly. And I think today, by his estimate, I have been unable to verify that, but I think that the most prudent course given that is for the court to address the credit time that he's entitled to as it sees fit. And I had that down as
It's tonight, sir. It's tonight at 12 o'clock.
Parole is?
Yes, sir. That's on the 24th.
Okay.
That's on my case.
Based on how
I
probation
always
likes
try to
to do
behave.
their credit time where they don't count the day of sentencing, I don't know why they do that, but he's been in custody since 12/5/25, which means that if you don't count today, he has 139 days credit. If you do count today, it is 140 days credit. It looks like he's in custody at 140. Mr. Keckler.
As a friend of the court, Judge, I advise the prosecutor and Chris. I've recently been involved in this issue, and I can tell you, I recently had a case where my client was arrested on Christmas Eve, December 24th, for a habitual traffic violator, and was put on ROR, parole hold warrant took effect. When he was sentenced on that parole, sentenced, he was given probation, and so he went to the DOC to deal with the parole violation because he also had failed to report in a couple other matters other than the new case. So he has written me, and I've got verification. Parole took the position that they're not giving him credit for the time here in our county jail. For some reason, they've evidently got some policy that when they hit the DOC, the parole board doesn't compute that time, and the DOC did not give him the credit from December 24th to his sentencing, which was about 3 weeks ago. So just as a, you know, it is an issue now that it's coming up, and I don't know, I'm going to write to both the administrator at the DOC and the pro board and say, you know, this really isn't fair. If he loses those 3 months that are not applied to his parole case because his parole was violated and he's serving a balance of the sentence on parole, Judge. Thanks.
Thank you, Mr. Keckley, for that anecdotal evidence. It supports your position, Mr. Kozlowski.
Yeah.
So, Mr. Keckley gets a stat from the assistant.
I'm always happy for Jay's assistance.
Very good. Okay, so having that information, that's good to have. So do you concur with the state's estimate of about 140 days there then?
Yes, sir. I have 130.
I know they can get off early, but do they get good time on probation? So, like if they're in jail, they get one good day for every day they spend. Do you get good time on probation?
39 as well, using probation's normal method.
Got it. Okay. So, that being said, I did forget to ask witnesses to testify for either side.
No. There you go.
Right. Sometimes I assume and I'm wrong, so I come to this. All right. So, then that issue kind of being polished up and a fine point put to it. Mr. Kozlowski, the balance of your argument recommendation, sir?
Thank you, Your Honor. As we've noted, we're asking for my client to receive 139 days of credit. What we are here for is a resist case and paired with a habitual traffic violator. You know, my client, you know, admitted in the factual basis that, you know, he panicked. He knew that, you know, he was in some trouble here. And Your Honor, looking at the criminal history, you can see why. You know, this is not his first go around with this particular situation. And I apologize to the court in advance for the rant that I'm about to go on, but this is a bit of a hobby horse of mine. We have created a society where if you do not have an automobile and you do not have a car, it is very difficult to just simply live your life here. Now, my client is adding to that bad pool by making some very poor decisions in not only driving, but then fleeing law enforcement. And you see that that is something he has done a couple times. So, you know, this is not to excuse, you know, my client's actions. I am simply saying that this is the situation that we have put many poor people in, that we have a bus system that runs every hour with no shelter, and very inconsistent timing on the buses arriving. You know, we have people here in court.
You just said it arrives every hour. That's pretty damn consistent timing. You just said there was a bus system. That's how you get around. So he can't make it around? He can't get around with a bus that runs every hour?
All the time that are talking about missing the bus and things like that. It is very difficult to make it around with public transit here. Now, again, that does not excuse his actions because he still made the decision to both get into a car and then to drive that car away from law enforcement. I'm simply trying to explain that when we often see people with repeated habitual traffic violator, I think that is a clear sign that we're not doing enough as a society to provide people with the means to get around town. So I would just offer that as a I guess, light informal mitigator here. Looking at his criminal history, yeah, you know, we do see those operating cases, and we do also see, you know, those resisting cases, particularly back in 2020. You know, he had a similar thing, but he has also been stopped many times without fleeing. You know, this has been the pattern, you know, going clear back to you know, 2013, 2012, you know, back when I was just in law school. You know, he was in these situations. What we're asking for here is for my client to be released from the St. Joseph County Jail and to be placed on probation. My client, I'm hoping, based on the conversations we have, that he understands full well that he can't drive anymore. And he's talked about, and he and I have talked about some alternative plans for how to get around. He's very fortunate in that he does have children in his life. And those children have expressed a desire to help him get around, and they have vehicles and transport for him. So he is trying, you know, based on our conversations, to find a positive way to kind of move forward here. I know that's a big ask, given how much history he has and how much repeated resisting law enforcement cases he got. That's the biggest mark against him, and that's what we talked about was kind of his biggest thing was that, you can't just take off from police, and he's putting the community and the officers in danger, and he knows that, but, as he said in the factual basis, he panicked, and he knew he was going to get arrested. He knew he was on parole, and sometimes when you're in those flash moments and you feel the wave coming down on you, you just want to turn and get away from the wave in any way you can. And he didn't do right. And he knows he didn't do right there. If the court isn't willing to go with our recommendation for probation, I think that my client is a good candidate for community corrections here. He is making very bad decisions, and, the word I used was stupid decisions when he and I talked. And again, I think he recognizes that. I think if he can get his life kind of in a place where he doesn't feel like he has to be driving to get where he needs to go, he's going to be in a lot better position. And having, him having the specific guardrails for you can't go places without permission, I think that's going to prompt him to come up with a plan, because it's not like you can just leave and go out and go to work. You need to contact community corrections. It needs to be approved. He'll need to be thinking about how he's going to get to the place. So I think having that guardrail is going to make him stop and consider his actions, and hopefully start to develop some better habits and better hobbies, because, he's never going to get his license back. I cannot imagine
Very true,
the BMV would, given his history, would ever give that. So he needs to start thinking about how he's going to live his life without a vehicle. And I think that community corrections is the way you can do that. So we're asking for him to be placed on probation for 30-month sentence, less credit time. But if the court isn't willing to do that, we would ask for a 2-year sentence executed on community corrections with no probation. Thank you.
Thank you, Mr. President. Thanks for the options. Mr. Wexler.
Gary has 25 priors, 15 misdemeanors, 10 felonies. He is on parole. He got HDB case. According to the PSI, his earliest release date is September 14th of this year. That's between him and the parole board. I don't know anything about that. Your Honor, I hear a lot of what Mr. Kozlowski is saying, and I agree with him that we've set up a structure where if you don't have a vehicle, it's very difficult to live your life. I think the problem is, and I understand that Mr. Kynes made the decision that he knew he was in trouble and made the decision to flee. It's not the lack of a license that is a concern for me. It's the fact that he chose to take the road that he had traveled and then endanger everyone else around him by fleeing from the police. Is there a point where we could wind back time and figure out where along the line we could have helped Mr. Kynes get a license? Maybe that's not the position we're in. We're in the position that we're in today, and we can't change that. Again, taking that concern for yourself and then endangering everyone else around you is the state's biggest concern. I know there are many defendants who find themselves in that situation and make that choice. There's also defendants who say, well, I guess they've got me and I'm gonna, take my licks and move on from there. It's not a universal choice to hit the fight or flight button. And Mr. Kynes, this isn't the first time he's done this. This is far from the first time. He has multiple prior resists. He has multiple prior PTRs. I don't think Mr. Kynes is a safe bet for probation. He has a bad track record, and I don't know what. I guess I see Mr. Kynes in a different light than Mr. Kozlowski. I haven't worked with him, so maybe there's interpersonal things that I'm not aware of. But the Mr. Kynes that I see on paper is one that is not a safe bet for probation. I don't know how he's going to do community corrections. I'm shocked that MCC agreed to take him. I know that he receives Social Security disability income, but according to PSI, he hasn't had a job since 2018. So I don't know how precisely he's going to pay for community corrections and, maintain at least a stable living structure, outside of whatever support he receives from his family.
Wait. Sir, doesn't community corrections put you on the course to a job and stability? That's how he pays for it.
you know, on the one hand, I do think that Mr. Kynes does need to have consequences for his actions. On the other hand, I don't think it's fair to set Mr. Kynes up for failure by placing him on probation or community corrections and then seeing him again at 6 months when either, you know, he doesn't have the money to pay or whatever it might be. All that said, Your Honor, he has the mitigator of accepting responsibility. He has the aggravator of his criminal history and being on parole at the time of the offense. You know, I give him the discount of that acceptance of responsibility. Given that, Your Honor, my request is 24 months executed on both counts. They are to run current. So it'd be a total sentence of 24 months.
Thank you, State. Mr. Kynes, anything you want to say, sir?
Yes, sir. First of all, I want to apologize to my community about my action and my wrongful doing, sir. I take full responsibility of my action, and I know wrongful right. I'm 45 years old, so I just want to apologize to the courts also, and to my family, and to my wife, who I hurt, and my children, sir. So I just want to do better from this day forward, sir. I gave my life to the Heavenly Father, so just want to allow a chance, sir.
Thank you, sir. Mr. Kozlich, you talked a little bit about, you know, you panicked in the moment. For a guy who's been arrested 30 times, I'm surprised your heart even gets excited about it anymore. I mean, that's a lot, Mr. Kynes. That's a lot. That's a heck of a criminal history, and that is an aggravating circumstance that is really tough to get over. You did accept responsibility to this offense, but that criminal history does outweigh that. Could we have done something better in the past? Maybe, but we did. So here we are. Ultimately, every day you step out the door, you got a choice to make, and you acknowledge that, and you have to live with those choices. The state has asked for 24 months. Now, given the fact that you have prior resisting law enforcement, where you've fled in a vehicle, that's pretty disconcerting, dangerous to the community, dangerous to you. We're lucky you're still alive. Under the circumstances, an aggravated sentence would be warranted, an aggravated executed sentence would be warranted. Although, what I think I come down to in this case is you still have some issue to deal with parole. We will give you that 140 days of credit that you've earned since being arrested in this case. And I'm going to sentence you to 9 months on each count executed. So you're going to have to finish that out in the jail. And then, you'll be out with no probation, no extra strings, no extra fees or costs. You'll find some costs in this case are going to be waived because you're incarcerated and you're going to stay incarcerated. What I'm giving you here, and of course, these counts are concurrent with each other, but consecutive to any time you get on that parole case, which is why we're taking your credit days based on what Mr. Keckley and Mr. Kozlik, you argued for you. So parole's going to do what they're going to do, and I can't worry about that, but we would be consecutive to that. Okay, sir?
Thank you.
What I'm giving you here, I guess, that the olive branch that I'm extending is you'll get out and you'll have a clean slate. You'll be able to start fresh, right? And you'll be able to figure out, you won't have to worry about going to probation appointments or things like that, worry about going to classes or any of that stuff. If you need to do that stuff for you, then do it. Great. But it'll be up to you to arrange rides and everything else. So we're not going to kind of recognize that this guy can't drive. We're going to make him go places and do stuff. You know, so that's what I'm offering. It's kind of a clean start. You finish this time, okay?
Yes, sir.
I wish you luck, sir.
Thank you, sir.
To clarify, I apologize. I just want to make sure I understand correctly. Is the court saying 9 months real or nine months an actual 9 months, which would be with this credit time? I believe he would be time served.
Yeah, no, 9 months real. So it's an 18-month sentence on each count. I'm sorry.
That's okay. I want to make sure that I understand.
Yeah.
Thank you, sir.
Because he didn't say 18 months on each count. He said 9.
I misspoke on that. and do the math in my head, and then that's what comes out of my mouth.
So he's going in for 9 months.
Jump the guns for guns.
Because he does get Class A credit for that 140, so that's 280 days that he'll have served towards the time.
But then he has a probation violation for picking up this case. And he'll get time for that, and that'll be consecutive.
Who said?
Go ahead.
BI, 22
9 months.
months. Holy cow, thank
9
you.
months real, and you've got about 3. Yeah, about almost 4 months in. Okay.
Yes.
There's a
So you're about halfway.
I gave you the map.
Yeah, that's
Happy
reminded. That's what
birthday. Oh my God, that's awesome.
Not years. Okay.
Yes.
All right.
You get lots
Good
of
luck,
chocolate
Mr.
and
Grimes. Wish
champagne.
you luck.
Thank you a lot.
Yes, sir.
Mr. Giles. Good luck, man. Yeah, stay off the road now. Okay.
Stay off the road now, as lawyer said.
Next year I have Brian Banachevitz.
Now that we find out it's CJ's birthday, the stream is over. Happy birthday. Alright guys, thank you so much for coming out today. I really, really, really appreciate it. Today's Wednesday. So there's going to be a stream in a couple hours at 8 p.m. Eastern Standard Time. I'll try to get something good for then. I'll see some of you there. I'll see some of you tomorrow morning. Behave, okay? I'm glad you found this channel, BI, 22 months ago. I know it was longer than 22 months because I got demonetized for that little period of time. So everybody's memberships were gone, and then they had to become a member again afterwards. But I appreciate it. Thank you. Alright guys, behave. I'll see you again real soon. Bye.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time. Oh, Kathy's the creator, she's leading the way. At Court Vibes, So what